Now, the former minority leader, Haruna Idrisu, is urging the public to ignore a supposed letter believed to be from the presidency, and that is his response to the LGBTQ bill. And at a press conference, the Tamale South MP described the release as a monumental threat to Ghana's democracy.
President himself writing directly to the Speaker of Parliament, as is required of our standing order, so that officially this can be read as communication from the President. So ideally, this paper means nothing and should be ignored by the clerk, because communication to Parliament must be communication signed by the President, addressed to the Speaker of Parliament, as is required of our standing orders, whether old or new. 2, yes, there is a matter before court, but I'm also a trained lawyer. An attempt to seek an injunction is not the same thing as an injunction. An attempt, I'm seeking an injunction, does not operate the same way as an injunction have been so granted by the court, even if it is an interlocutory injunction. But more importantly, Parliament cannot be enjoined not to perform its lawful function as the legislature of Ghana, clothed under Article 93, responsible for legislation. No organ of state. Subject to the Constitution. The judiciary is subject to the Constitution. The executive is subject to the Constitution. The legislature is subject to the Constitution. So it's for good reason that all of them, the Constitution says, subject to this Constitution. The legislative authority is vested in the Parliament of Ghana. Now, somebody should help me with the 1992 Constitution and open Article 106. Then 2, the President cannot, by any shred or shadow of authority, seek to injunct Parliament from exercising our lawful duty and responsibility as the House responsible for lawmaking. Neither the courts can enjoin Parliament not to perform our duties as Parliament. The courts, under Article 2 of the Constitution, can declare a nullity or a void to the extent that Parliament have passed a law which is inconsistent with the Constitution. As far as me, I'm concerned, even with my understanding of the law, there is nothing before the court, because a bill remains a bill. Until it's assented to by the President, it is not law. Therefore, as far as I'm concerned, there is nothing before the court that somebody will seek to use that to injunct us from performing our lawful duties. That's why the Constitution in Article 106, if those of you who are familiar with it, it reads, the power of Parliament to make laws shall be exercised in bills passed by Parliament. In bills passed by Parliament. So Parliament has passed Human Sexuality Bill, assented to by the President, Article 106. It has not been assented to. So there's no law yet. So whoever is seeking to question a law must show us which law he's referring to. But Article 106 imposes an obligation on President Nana Addo Dankwa Akufo-Addo as the executive head of the Republic of Ghana. It says that when Parliament passes a bill, Parliament shall remit the bill to the President for assent. That is what this Bedioto letter is seeking to do. And you have to read it well. He says that they were at Peduasi Lodge on 14th March when the clerk attempted to serve them Human Sexual Rights and Family Values Bill 2024 at Jubilee House. And that the office is aware of pending applications. So he himself is a lawyer, pending applications. A pending application does not operate as an injunction anyway, pending application. But in any case, what authority has he writing to the clerk to do what? But we find the words here in relation to the bill. It is not for the Attorney General to advise the President not to take any step. The Constitution dictates what the President should do. Assent to it or refer it back to Parliament with an explanation, or to the Council of State. It didn't say he should refer it to the Attorney General. Yes, Article 88 gives him a mandate. The Constitution is very clear. So what we want to do, and it's part of the matters I'll raise before Parliament, we must now know when did Parliament remit the bill to the President, and we will count 7 days. If 7 days have lapsed and he has not assented to, and he has not written back to Parliament, nor to the Council of State, we'll hold the President responsible for a constitutional breach. And he should know the legal, lawful, constitutional consequences of his action. So this is why we've called to address you that it's a matter of grave constitutional threat to our democracy and to the proper and effective functioning of the constitutional structures created by the framers of the 1992 Constitution.